Hello and welcome everyone to the English Show. My name is Stephanie here at Beltran Brito, accompanied by my partners, Gil Brito, Alexis. Gil, how are we?
Good. How are you guys doing?
How are we doing, Alexis?
Life is great. Life is great. Can't complain. I mean, I know we're going to talk about something that is so exciting to all of us here.
Is torturous, quite frankly. So honestly, I'm not excited for today, but I know you guys are because we're actually going to talk CSPA mostly. We're going to be answering your questions. So as always, please go ahead and ask your questions via all the platforms, LinkedIn, YouTube, Instagram. Drop your questions in and we'll go ahead and answer them throughout the show. But our main focus today will be essentially CSPA and the CSPA calculation, which for those who don't know, which is essentially how to protect a minor child and ensure that your minor child is included in your immigration petition before they turn 21. That's the main crux of it. Boys, please take it away.
Before we get into that, do we want to address any issues or just kind of start
Any
running
news?
on CSPA?
Are we just going CSPA? Okay, so
we got some news, maybe.
a little bit of news. I think people have forgotten how jurisprudence works.
Let's talk the pause. Yeah, that's a great point.
So I'm getting a lot of emails about this, which obviously we're well aware of the situation with the Venezuelan pause. A judge in Rhode Island ruled in favor of Venezuelan nationals, saying that it was not right to have these cases delayed, etc. And everybody goes on social media and says the pause is lifted, everything's fine. And then that's not true. Okay, that's not true. It's not lifted officially by USCIS. USCIS has zero information on that. One. Two, you need to expect that if you're in a court system, you have the right to appeal.
Correct.
They will appeal that to a higher court.
Correct.
We're pretty sure of that. I mean, I really doubt, Stephanie, Alexis, that it will not be appealed, as they have appealed all these other decisions. So I imagine it's going to be appealed. And then depending on that, maybe we'll have a little bit of more guidance. What do you estimate is the time period of all that appeal and waiting game?
Minimum another year.
Yeah, I think so.
Appellate process, minimum another year.
Yeah.
say
So it could still be a while, I think. I would say on that appellate process, it might be a while. They might just lift the pause on their own volition.
That's my opinion.
I think that makes more sense. So hopefully sometime this year, but it wouldn't surprise me if it's 2027. At this point, we're on month 6 of the year, even though that's crazy to say that half the year is literally in 3 weeks, it's gone.
Yeah.
So we only have 6 months left of the year. So the reality is that it may be for 2027. But this idea that just because there's a judge's order and it's done and that's it, and USCIS doesn't say anything on it, no. What happened to the doctors was different because USCIS immediately came out and said, "Okay, yes."
They reaffirmed it.
They put it in their policy.
Yeah, and they put it in the policy. So that group of individuals was affected directly by the lawsuit and the judge's order. But for the Rhode Island group, no, unfortunately, that does not change anything today, right now. Maybe next week they lift the pause. I just don't think it's going to be so quick.
And then to be clear, just for clarification, as far as countries, this is the 19 country one. Notable countries, I would say Venezuela, Cuba, especially for our audience, Afghanistan,
Haiti,
Guinea, Eritrea, Haiti, Iran. That's sort of one of the, I would say, the main ones that we're going to be paying attention here.
Well,
so this is the 19
expanded
country
to the
ban.
39. It was expanded to 39.
But the Rhode Island thing, I think, only
Was on
addressed
the
19.
I think it only said
Only on
19.
I think he only
Yeah.
addressed 19. It was very specific. But I'll verify that for you. Island judge.
And by the way, it's only USCIS. So people are asking consular processing, what's going on, and it's not one of the ones that we're worried about.
Oh no, okay. So the Rhode Island judge did address the 39 countries explicitly.
Excellent.
Regardless, those are some of the main countries. So it's addressing those, right? All right. Any other news that we
Did
want to touch
Alexis
on?
just school you?
No.
And you're just brushing that off?
That's why I pressed it.
Alexis
He would
just
never.
schooled you
He would
and
never.
me, by the way, and he schooled both of us because the fellow could read.
I can't keep up
So-
with the numbers at this point. There
is
was 12
confusing.
countries. There was 7 countries. There was 19 countries. There's 75 countries. There are
Don't forget
39
the
countries.
75 countries.
Right,
Yeah.
right. Like it's
Jeez.
like a million different ones.
So that just discussing that that it sounded like good news. I think it is good news. It's positive. It's the right move for the court, definitely.
Absolutely.
And it's very positive for our clients, but I just don't expect immediate action on that.
We also, speaking of courts, which exactly to Gil's point, move slowly. Yesterday, they struck down the $100,000 fee for consular H-1Bs.
Yep. Which they could still appeal, obviously.
They could appeal.
Which, to Gil's point, they will appeal it. I don't even think they're going.
I wonder how many companies actually paid the $100,000.
I think there are some companies that
You think so?
The reason is this: if you're hiring, I'll just give you an example.
Well, wait. To be fair, they wouldn't have paid it yet.
Oh, right.
Well, they
But
would've paid it
but they're willing.
I'm
I'm sorry, they're willing to pay it.
Yeah.
They're
Right.
willing to pay it, and the reason they're willing to pay it is because a software engineer for a major AI company is being paid $400,000 or $500,000
Mhm.
for a national or American, and for them, it's like it's part of the compensation package, $100,000.
Sure.
Like,
It's
I think-
Oh,
200,000
like they're
now.
opening
Yeah, I think
Which
so.
you're not
Yeah.
supposed to, by the way.
a starting
But-
bonus.
No.
They figure it out.
They're definitely not putting that as the compensation
Exactly.
package. But what I'm saying is they're considering it just another expense to have this employee, which we are already spending hundreds of thousands of dollars. If your
Absolutely.
H-1B employer is paying you
Mhm.
$80,000 a year, there's no way they're going to pay the $100,000 fee. Like, that's just not going to happen.
So essentially to the same thing. So a judge struck down the $100,000 fee for consular H-1Bs, but now what we're expecting is that a decision will likely be appealed by the government, and then we'll go ahead and see it play out. My curiosity is the quicker that moves, the quicker that may potentially not be applicable for the current round, which, remember, for those keeping track, H-1B petitions are due that were chosen in the lottery by June 30th. Please be attentive to that date because you need to file your LCA, and LCA takes 10 days of Department of Labor. So the date is really, really creeping up.
Isn't that fun?
Fun.
Every week there's something new.
Do we really have to go into the torture already?
Into the what?
Into the torture?
We do, yeah.
Oh, yeah. CSPA?
Yeah.
Let's do it.
Yeah. Okay, so
Let's go.
let's just start with this. What's CSPA?
Alexis?
The Child Status Protection Act. We'll start with that. So CSPA is a way for USCIS and the Department of State, so for immigration officials, to determine if who was your minor child at some point in the process still qualifies.
Qualifies for an immigrant visa or a green card?
Correct.
Correct.
Yeah.
And so therefore, the idea is that this person, right? Everyone's considered a minor child or derivative beneficiary up until the age of 21, assuming they're not unmarried.
Mhm.
So we'll start with that. Now, if they get married, automatically disqualified. Doesn't matter the age. So this is only for unmarried individuals. Up until the age of 21, they can form part of the family, the nuclear family, and receive the benefit of the green card as a derivative beneficiary. So CSPA was a way for Congress to address the issue. I forgot how long ago it was. I think it was like
2002. 2002.
Okay.
Yeah.
So 2002. And they're, depending on the type of visa, right? The statute might change and the formula will change.
Right.
So who does this help? Immediate relatives, family-sponsored petitions. So think of all the preference categories. VAWA, violence against women, employment-based, so EB1 through 5, diversity immigrant visas, which that also includes a whole slew of people, refugees and asylees. So depending who we're talking about, it changes.
Correct.
What's a simple one? Give us a simple one. You got the simple one.
As in, what's the formula for one of the categories?
Sure.
So immediate relative,
Okay.
one of the main
Mhm.
changes was that your age, the age of the child, locks at the filing of the I-130 or the I-360 in the case of VAWA.
Mhm.
VAWA would only be applicable because it's immediate relative to U.S. citizens. So if you are the child of a U.S. citizen or the spouse of a U.S. citizen or the parent, only child, then you would be protected when you filed the I-130 or the I-360.
Exactly.
So it used to be that you had to do something else
Mhm.
for that. So just having the I-130 pending does not necessarily mean that your age is locked in for CSPA purposes. Now with this change, just having an I-130 filed and either
Mhm.
an exclusively immediate relative, not preference categories.
Correct.
Okay.
Which
if you're a
that
preference
is
category,
excellent.
That's completely different.
Yeah.
And by the
That
way,
is truly excellent.
it's wonderful news because it keeps it simple.
Correct.
And what happens is sometimes you might become, you might turn from immediate relative to a preference category, what, F1 or F2,
Yeah.
F2B.
Before you would have to jump to F1,
right?
Yeah.
So
previously.
that change would affect you, not affecting you anymore. And by the way, another kicker, USCIS has its own kind of set of rules. Department of State has its own
Right.
set of rules. The idea is now today it's pretty much unified across the board.
That was the
But
major change.
You
Let's
should
say.
always check.
The major change that happened in 2025 was that adjustment of status was a little easier and consular was a little more difficult for the CSPA calculation. Now, for the majority of the categories, including primarily, I think for this channel, employment-based, now the calculation for Department of State, so consular processing and adjustment of status, USCIS, is the same.
Let's go back for a second on the immediate, just to be very clear, when we're talking the I-130, it's exclusively for immediate relatives. It is not for any preference category. What's a preference category? That's the, different preference categories. For example, I'm over, this doesn't work F1. I mean, we're not going to apply CSPA to this, but I'm over 21 and my parents are a United States citizen. But specifically for the categories of, the big one I would say is probably going to be like F2A, but F2A or F2B or F3 or F4, which is sibling petitions, so you're like, oh, wow, how, people really do CSPA for those cases? Of course they do.
Oh, yeah.
Because I petition my sibling that has 4 kids under the age of 21, and I'm sponsoring that entire family, and I'm petitioning for that entire group of people. So yes, even though it's a case that takes 18 years, if it was pending with USCIS 10 years and your kid's currently 30, guess what? They're part of the petition because they're only 20 years old for CSPA purposes because the case was pending. But now we're going to be talking about the formulas. We're going to be talking about that. I just want to be very clear about immediate relative. In the case, and I think this is a good way of proceeding, let's start with family and then we'll work our way to the more difficult calculations, okay? So the second level of calculation, let's just use my example of F2A.
Okay. So spouse or child of an LPR.
Of an LPR. We're going to go child, obviously. Okay. LPR under the age of 21. They did it. That case was pending with USCIS for 3 years. The person is now 22 years old. In other times, Stephanie, they would just bump that kid to F2B. And they would just say, you're F2B now. You're no longer F2A. You're over 21. That's it. That happened to me a ton of times. At the consulate, okay? Never with USCIS, I could say, but at the consulate, that would happen to me frequently. I would just automatically get a notification from the MVC that says, hey, by the way, you're now F2B. Sorry. And we'd argue whatever we want. Like, no, we're making the determination. Now, in my example, the case is pending 3 years. The kid's 22 years old. They're 19 years old for CSPA purposes because the petition took 3 years to be approved. Fine. The kid is in. Here's the other example. Now the kid is 22, but the case was only pending 1 year.
You're 20, let's say you're 21 in 2 months, 21 in a day.
Yeah.
You don't qualify.
Maybe you don't qualify. That's the issue. So it's really important to clear that up, especially with the family cases, just to be very clear. We are only looking at the time that the petition was pending. That is all they're giving to you, correct?
And the petition, we are referring to an I-130
yes,
or an I-140 in case of employment. Now, the reason I bring that up is because you think of petition, is it the labor certification? Is it this? The petition they are referring to into the calculation is I-130 or I-140.
And I think even some VAWA.
Or I-360, but I-360 would be VAWA, we're fine.
Right.
Well, unless it's LPR, F2A, yes. So I-360 could be one of the forms as well if it's through VAWA, correct.
So the thing is, so what's the determination? What do we want to know? The kid's age, right? The CSPA age. So they call it the CSPA age. And there's a very specific formula. And there was a time that it was flexible. And I think, by the way, if you had a case pending, maybe don't quote me on this, but I think it's February 14th, 2023.
Previous to August 2025.
August 25.
Yeah.
During that period of time, there's flexibility.
Right.
But today, and even previous to that, there was a different change. But today, let's talk about what it is today. It's very direct. The formula hasn't changed. It's the interpretation of the formula. Age at the time of visa availability minus the time the I-130, I-360, or I-140 was pending. That equals your CSPA age. So the easy part is what we're talking about now. How long was an I-130 pending? How long was an I-140 pending? How long is an I-360 pending? That, it could be 1 year, it could be 12 years, it could be premium processing 15 business days, right? 60 business days. So that's a number that you're going to get. But that determination is made on the date of one of two things. The date the petition is approved, or the latter, which is the date of visa availability based on the final action chart.
Okay, it's
And-
gonna
and
get
this is-
real confusing.
this
very
is
Gonna
quickly.
get
where-
real
This
brutal
is where it
here.
gets fun.
Okay, let's go one by one, right? Visa Bulletin has two charts. Always remember. It has chart A and chart B. Chart A, we call always final action.
Mhm.
Chart B, we call dates for filing. What does that generally mean? On a general sense, dates for filing should be when in a consular setting, the consulate should start working on the petition and basically collecting preliminary documentation. And then table A, which is final action, is basically if they are already able to issue the immigrant visa. In a USCIS setting, it really doesn't matter because they tell us every single month what chart to use. It's very unique for USCIS.
To
They just
determine
say-
when to file.
Correct. They tell us, hey, listen, this is the chart you're going to use in order to file. Now, before, a visa availability was understood on specific charts, and we'll go into that now. But the important thing for now, the CSPA calculation, when is the visa available? When it is good on the final action chart, on chart A. So it doesn't matter when you were able to file. They're going to use when it was available based on the final action. So final action chart, chart A is what guides for CSPA today in a post-2025
But if
setting.
the I-140 is approved, if the I-140 is not approved yet, we could use the I-140 or I-130 approval date,
The later date.
the
correct.
later date, which may be very beneficial potentially.
Well,
Because it was pending
depends.
longer.
It's also
So it's the
odd.
latter of the two.
Yeah.
So we'll go with this example. My I-140 was approved today, and we submitted it 15 business days ago. But the final action chart is still not current with your priority date. Maybe it's if we filed 15 business days ago, we filed May 2026, but on the final action chart, it's January 2026.
Yes.
Guess what? We can't use the I-140 date.
because the later date will be the final action date.
Will be
Yeah.
the final
Will
action
be,
because
yeah,
you assume
right.
it's going to happen.
Which, by the
next
way,
month
in the
or-
majority of the cases,
it's that.
it's the
Majority.
I-140 date's going to come way before the final action date in the majority of court. Okay, I just feel it's a very confusing thing, so I just want to
Super.
I want to get into it a
Get,
little bit
get
more.
the examples.
Yeah.
That's how we explain it.
Let's talk about this scenario because I felt that this is the most confusing part of it. Is we go ahead and we file in I-140. I-140 is approved. The child's biological age is maybe over 21 or maybe even under 21, Alexis.
Sure.
We file an adjustment of status
Mhm.
based on the dates for filing chart because that's what USCIS said we could do it.
Mhm.
Mhm.
We file the I-45.
Mhm.
This
The age is
kid,
still sumando.
the biological age continues to run.
Correct.
And your biological age is not stopped just by having an I-45 filed. I'll tell you, for many, many years, that was a thing.
It would
Okay.
it would freeze.
That's the
It would
big
It would freeze
difference.
the date.
So guess what?
Right.
That's the difference.
If your kid is now 6 months into the I-45 being pending,
Mhm.
and there's a visa number available according to the final action dates chart, they might be over 21 for CSPA purposes.
Mhm.
This is what I think is the most difficult concept
Yep.
of the change.
100%.
Okay, of the change, because it took us quite a while to understand it and conceptualize it. Like, oh, then the adjustment of status doesn't matter. Like
It
when you
doesn't.
like, I'm
It
sorry,
doesn't.
it matters in the sense as from a visa. We haven't mentioned this yet either. From a visa number becoming available, you have up to 1 year to file an adjustment of
Correct.
status application. Okay, but that does not mean that the age is frozen.
Mhm.
Okay. That means because you had your, maybe the kid is 19 and you took a year to do whatever. So
Yep.
the idea that all these kids that are turning 21 are automatically eligible just because we filed an I-45, I think we have to discard that idea.
Absolutely.
I'm not saying not to file an I-45 for them. I'm not saying not to argue it. What I'm saying is you better maintain, if in the United States, that child's non-immigrant visa status with, for example, something I do a lot, F1 visas. Okay, so we go ahead or we get them F1 status, we change them to F1 status, and they file an I-45. And you say, well, there's a dual intent issue there. It's like, I understand there's a dual intent issue. We still need to keep that F1. Okay, I have to do the F1 to preserve their status until the green card is approved. Green card's approved. So we have a lot of these right now. Okay. And I'm like, hey, you have to keep the student status like up to date until the green card's approved, because that's the only thing that's going to protect your child until we find out. Immigration officer has the discretion, by the way, to approve your case, regardless
and
of the
if it's
calculation.
hard for us,
okay,
believe me,
I think it's hard for everybody.
Hard for the officer.
For everybody.
Like if it's hard for everyone, it's hard for the officers. So that's why I'm of the opinion to still file. I want to dial that back, but I think it's really right. I think it's worth.
We're not saying don't file stuff.
No.
Right.
Yeah.
So I think it's worth really repeating this. You have to have a non-immigrant status, say for 245K, when you file your adjustment of status, right? Let's say you are jumping from 01 and your children's have 03 and you're going to an EB1 adjustment of status. If you have a child, I'm going to say really 19 to 21, if you have a child in that age range, you need to seriously consider changing that child from 03 or whatever non-immigrant derivative status they have to F1, their own student petition.
Absolutely.
Before you file their adjustment of status, so that if the CSPA calculation does not go in their favor, because now the calculation isn't done the day they file, it's done later down the road, then God forbid that I-45 is denied, then they can stay as students in the United States. So that's an added element of what you need to be considering in your immigration process. And I also want you to understand, you can file your adjustment, you adult, right? While the F1 is pending. I don't mind that if you're concerned about time and these things and visa bulletin and all that. But I need to be considering changing from 01 non-immigrant derivative to F1 for the almost adult child before you file the adjustment of status for that nearly adult child in order to always protect them. And I do not want that adult child using a work permit connected to the adjustment of status. I know I'm very conservative. I have to be conservative, especially right now under current times and current administrations. I do not want that child using an EAD connected to the I-45.
It's just, listen, this is the truth. The simple, hard truth. You're not going to know when to file. When the determination is made until the final action charge is made available.
Yeah.
Okay.
That's
so
it.
let's okay. We got to deconstruct that a little bit. That is the complicated idea.
And that's month by month.
Yeah. So every single month the final actions date chart will change. However, or sometimes it'll stay the same. Okay. But let's assume. I don't know what that was. Did you get a little?
Said help is on the way.
Oh, really? Oh, good. Maybe it's SOS.
Someone help me with the final action chart.
So another earthquake? What's going on?
Final action date chart. Like I said, the adjustment of status does not stop the clock running. USCIS cannot determine the CSPA age until a visa number is available pursuant to the final actions chart, table. So what does that mean? That means regardless of that you filed an I-45, your child may still not be eligible for a green card based on CSPA. Because when they do the calculation, actually, it could really hurt you, I think, Alexis, right? It could really hurt you, the fact that it takes a while to get a visa number available, or even if there's retrogression. The time. Yeah, retrogression could be a disaster for you potentially. Because previously I would say, oh, the I-45 told it and you're fine, but that's not a thing anymore.
So
what could also be disastrous is paying premium processing.
So that's what I was going to get to next.
For the main petition.
For the main
petition. What is the other part of the calculation? The pending time of the I-140. So if you have a child who's borderline and you say, well, I've been looking at this chart for the last 6 months and we're about to file the I-140. So this is part of the strategy. I mean, this is why it's so important to review this ahead of time. It's strategizing. But you're here strategizing and you see, man, I'm filing an EB2NIW. And up until about 4 months ago, EB2NIW was severely back.
Correct.
right?
Severely backlogged.
I mean, 2 years or more. Now it's current on one of the charts, which,
Mhm.
by the way, is the dates of filing.
Mhm.
So you can
No,
file
it's
an
current on both.
AOS,
It's current on both.
but that's current for CSPA, final action also?
Yep.
Okay, so it's current there.
This month.
But it wasn't 5 months
Mhm,
ago.
mhm.
And so when it wasn't, what would people do? You say, well, if I file premium processing, I have a decision within 60 days. So when I reduce the time, so fast forward in the future, final action chart says there's a visa available. The officer is going to say, what day is it today? How old is the child that day? And subtract the time the I-140 was pending.
Or the I-130.
Or the I-130.
Yeah, for preference category.
But if we're talking about premium processing, a lot of people want a decision quickly.
Yes.
Might not be beneficial if you want to intend
Because you're going to
somehow
subtract only 15 business days.
versus
Yeah.
a year or
Yeah.
a year and a half or
Yes.
2 years.
Yeah.
Some of these petitions are taking 26, 28 months right now. And you might say, that is unfortunate, but it's beneficial for your child down the road.
That it's pending
Because you're
quite a while.
buying
Yeah.
yourself time.
I mean, but is it beneficial? It's beneficial if there's retrogression, very beneficial.
Mhm.
Okay.
Sure.
If you have a current visa number available,
Mhm.
does it matter if it's pending a year or if it's pending 2 weeks?
That's a great question, because there, let's use EB1 as the example that's normally current.
Yes.
You want the decision fast because more than likely it'll be current,
Exactly.
because guess what? The date the visa is available is immediately when the I-1. So the day the
That's my
I-140 is
point.
approved,
That's
Mhm.
my
it's
point.
already available.
all-
So therefore,
It makes no sense to
want it.
wait. Yeah. I mean,
Right.
actually, in that case, you might even concurrently file in that case.
Mhm.
yeah,
I mean,
yeah,
it depends.
premium
you know?
processing, knowing
Yeah.
that it's more
I
than
mean,
likely
if
it
you're
won't
close,
change.
you know how it is.
Yeah.
A lot of our clients are like, hey, my kid is 21 in 3 weeks. You know what I mean? Like that happens
Hey,
all the time.
What if you get an
Okay.
RFE?
Oh, no.
The kid's 2
It's-
months away, but you get an RFE.
It's actually not bad.
Right? So
Yeah. If you get an RFE, yeah, but it delays the
you
process.
want
Obviously.
exactly.
It's
things
a
to
lengthier.
consider.
It's a lengthier
Things to
I-140.
consider.
Guys, I know this is confusing, but that's kind of the formula we have there. CSPA age is basically going to be your biological age at the time that a visa is available minus the pending time of the petition. So if the
Exactly.
petition was pending 4 or 5 years, I know that sucks. It's fantastic for if the kid's 24 and now they're 20 years old for our purposes.
You want to
Okay.
know how magical CSPA is? I had a
Tell us,
F4.
Alexis, how
Magical.
magical.
No, it is
Tell us how
magical.
magical it is.
Magical.
This was great. F4. So USC petitioning their sibling,
Yes.
and in this case it was the brother.
Mhm.
And at the time of filing that I-130, the gentleman had 2 children.
Mhm.
This petition was pending a long time, about 8 years, and then be given the category. It took about 20 years just to get,
This is a Mexican national, probably.
Exactly.
Yeah,
Mexican
Mexican national. Yeah.
and so takes longer. That's why it was almost 20 rather than 12 or 14. And so by the time we were able to file the adjustment of status, those 2 kids were about 23 and 24, and the new kids were born while the petition was pending, were 17, 18, 19. So those were easy. But the 2 kids, given that the I-130 was pending for about 8 years, their CSPA age
16?
was
Yeah.
16,
Mhm.
or in their case, it was like, and my math is off, but I remember this. One was considered 19 and some months, and the other one was 18 and some, 18
Amazing.
and a half.
Amazing. That's the benefit of that.
Right.
Exactly.
You're going to
Exactly.
see more benefits of this in family-based cases where the
Probably.
wait times are extremely long.
Yes.
You're going to see less benefits on CSPA and employment-based cases, particularly EB1 and EB2, where the wait times are shorter. So you have to really play along on the strategy of whether or not you're going to file with premium, whether or not you're going to file with your child within the United States or via consulate. There's a lot of different factors, and
Yes.
based on the type of petition, whether it's I-130, I-360, or I-140, that's really going to tell you how and what to expect, right?
Yep.
On this formula, what I want you to remember is age at visa availability according to Table A, final action,
Mhm.
and then minus pending time of your I-130, I-140, or I-360. So those are the little caveats on how to find those numbers, and that's going to give you my age. And I'm talking, this is to the
Your
date.
age. No, your age, we got to do a different calculation.
Yeah. You gotta count the rings on the tree. But this is, by the way, this is to the day. Okay. I have had a kid left out because he was 21 years old and 1 day. So you need to be calculating this as on a day thing. Leap years have an extra day. Like, this is very, very explicit and very specific. I hate, Gil was saying this earlier. Why does the USCIS website not a calculator and not have a
They
calculator?
just need to have a calculator
no
that with a
idea.
drop down menu that says what
Yeah.
petition. Okay, what category? What's the birthday? Okay, what's the date? Boom, here, they qualify or not. It should be like literally
Sorry.
2 seconds. Okay, unfortunately, it's not. It doesn't exist. There's a couple calculators out there, but be careful, guys, with those calculators out there, because those calculators out there were from a while ago. Okay, from the 2023 version, and I know they reverted back to some 2023, but it was even prior 2023 that those calculators existed, and that was basically the current law. Right now,
don't use AI. Let's do it by hand.
Oh, I'm going to tell you.
Don't do it by hand.
Oh, wow. I would love to pop that in AI to see how wrong they may be.
I mean,
it's 50-50.
so many
so.
of
It'll
the
get it right and then get it
websites
wrong.
were wrong.
What's that?
Remember back
The
then,
websites,
the
the websites. The
websites, the
websites were wrong.
CSPA calculation websites, I would use 3 and all 3 would get it wrong.
Let's do examples. Example
Yes,
one.
let's go.
Well, what's some of the information you need though?
Yes.
If you want to do the example, right?
Yep,
So
yep.
kind of looking at the
Yep.
little worksheet kind of we have here.
Do we have the worksheet available on the slide or
No,
not?
we're
just
just
on
going
the
to talk
logo,
about
yeah.
it. Yeah.
But I think first thing you need to know is what's your visa category. So
So
you know
let's go
what
straight.
you're supposed to
There we go.
consider. You're
Sorry.
supposed to consider this formula that we've been discussing, or is it immediate relative? And you just go with the I-130, I-360, and you're good. So first, know your visa category. I think it's key.
Is this just, okay.
Oh, it is available.
Yeah,
Okay,
It's
cool.
available.
Yeah, we
Good.
have
So
it
this is
there.
what we're looking at.
Pretty much.
By the way, this is directly from Department of State.
Yes.
Department of State gave this to
This is what
client,
the
and this
officers
was amazing.
use.
Yeah.
This is what the officers use. They gave this to my client, I think accidentally. And I was like, whoop, I'm going to take this.
But it's so accurate.
yeah, no, it's great.
This is the best way to do it. So you know your visa category, and then thereafter, guess what? You got to know their date of birth. Alien's date of birth is always going to be the child, the person
child.
who's CSPA age you want to determine. The petition date. So
Mhm.
that's the date you filed the I-140. A good one. What if I filed a perm, Gil? I mean, you have a priority date.
So, gosh, don't even get me started on the perms. So it's like I've been telling people for years because that used to be a thing, right?
was
Like
the
it used to be.
thing.
It used to be a thing that
Yeah.
you're using that priority date. So,
What was the rule? What was the rule? It
Well,
was,
I mean,
forget about what the rule was. The
It's
rule
gone.
now
no, no,
is
the
it's
rule
gone.
now is that it's the I-140
the
tolling.
filing
It's-
date.
It's the filing date of the I-140, the
I-140.
priority date established with the filing of a labor certification
Mhm.
or an ETA 9089 is no longer
A
going to be
consideration for
something
CSPA.
they're going to consider for CSPA.
Yeah.
Doesn't mean I may not argue it. Doesn't mean I may not argue it.
You
if
could.
I
I'm
have
gonna
to.
try.
I mean, by
So,
the way, it worked
I
once
may
upon
try.
a time.
Yeah,
so,
it-
so it
I
depends.
might still argue it on a few cases that I have hanging out there that we might want to do that. But overall, no, you're right. So look, use your example. Go ahead.
So you're going there. So make sure when you look at the filing date of the I-140, don't look at the priority date. Always look at the filing date. So that's the day you filed the I-140, regardless of your priority date.
So
You-
wait. So just to clarify for me, because now you're even throwing me for a loop. It is not the priority date, which is established by the filing of the perm. It is the filing date of the I-140.
Exactly. So
Okay,
so forget about we love priority dates because priority dates help us determine when we can file an adjustment of status,
Yep.
NVC, DS-260, all that, the expectations. So priority date is so important for immigration. For CSPA,
Yes,
But weirdly,
irrelevant.
it's going to be irrelevant. Yes.
weirdly
Completely
irrelevant here.
Yes.
So
Yes.
that's why very important the date of filing the I-140 and then obviously the date of approval of the I-140. So at least we have part of the calculation.
Mhm.
X minus Y, where here we have our Y. So the time the I-140 was pending. And that's going to give you the next point, length of time that the petition was pending.
And that's going to end up being the most important point.
Right. I mean, it's key. It's at least 50% important. And then date the petition became current. Why? Because there we're looking at the dates of filing chart. Sorry, the final action chart.
Yes.
Ooh, I almost got that one right.
So that's always going to be the first of the month, right?
The calculation. So it's
What do you
funny.
mean? What do you
So
mean? The first of the month?
Well, the first of the month is when the final action new date would drop, right?
yes.
So the date it became available on the June 1st, 2026.
Oh, I
feasible
see.
session.
It's
It's always
So-
the first of the month, right?
Exactly. So it would
Okay.
clear everything prior to
Mhm.
then, which is key. And then once you have that, you still want to know the date the I-140 became approved. You're going to compare the two.
Mhm.
And that's why I love this box here. It's a little redundant, but it just breaks it down. Pick number 3 or number 5, the date the petition was approved or the date the petition, the visa became available on the final action chart.
Which
Why?
nearly always.
The latter will
Be
usually be
number
the
5.
final action chart,
Yeah.
which is number 5. And therefore, then you get the age of the aliens. So the CSPA child.
That's
their
what the
date of birth.
calculation. That'll give us
Exactly.
the calculation.
And then you kind of run through the rest.
I don't know
of
if
the
this
book.
is helpful. This is confusing still. Like I imagine for us, it's not because we've gone through it so many times, but I imagine somebody trying to figure this out.
It's brutal.
It's
Why?
kind of confusing a little bit.
I mean, you're dealing
like-
with a lot of dates, a lot
Yes.
of numbers, a lot of subtraction,
It's
adding,
really brutal.
and if it's not one, it's the other. I mean,
No,
there's
and
a lot of
then
back
not
forth.
having a final actions date.
Right.
Available.
That's the thing.
Like that, not
you
having a
can't
final
really
action
make
date.
your final
You can't.
conclusion.
Yeah.
You
This
can't
could-
make your final calculation.
You
Let-
could fill in all the boxes, but you can't fill out number 5 or number 6 until the date the final action chart becomes available.
Which is why, so I hopefully our own clients are watching this, but they always get frustrated because they're like, how can you not tell me the calculation yet? I'm like, I
You're like,
swear,
it's true. It's like you're like, I don't know. I don't know what's going to happen.
We don't
yet. Yeah, I
know
don't know
when
what's
it's going to
happen.
become
Yeah.
current.
Well,
It's not a
that's kind of always
calculation.
been a thing, though.
I
with
always,
CSPA,
and they would
with
never
CSPA.
understand.
Yeah,
They'd be like,
yeah, yeah.
I don't understand. You can't calculate it until a certain date
Let's do
comes.
some quick examples and then we'll jump into the questions,
Yes,
guys.
let's
Sorry
do
for the delay. Example 1, Maria, age at visa availability, 22. Petitions pending, 1.5 years. CSPA age, 20 and a half. Results, protected.
That looks so easy.
This is making it seem so much easier than it is. These are horrible.
Daniel, age at visa availability, 24. Petition pending 2 years. CSPA age 22. Result, age is out.
It's
No,
really not this.
We didn't
easy.
even plan that.
I
No,
need-
that's just
I
simple
need you to
family
go,
based
like
cases.
this is like
Yeah.
yeah.
it goes
That's
to
just
the
basic.
category.
date.
Yeah, yeah, yeah.
Family
Okay.
based.
Yeah.
I really need you guys to understand it's not just 22 years, right? Or 21 years. It is to the date. So I am 20 years, 9 months, and 12 days. I have been penning the petition for 1 year and 12 days. So that it really needs to go that
It's going to be
specific.
that specific. Yeah. So this is just obviously very simple examples just for the purpose of demonstrating it. But
Mhm.
I would say the tougher one's always going to be the employment based.
Absolutely.
Yes.
Because like we mentioned, immediate, you're kind of okay no matter what, really.
Immediate, you're
as-
good,
As long as
which
you
is
follow
really
your own
nice
30.
change.
Hey, listen, of all that, that's a huge positive change for so
Yes.
many people. I love that they did that. The issue is now everybody else.
Everyone else got
Yeah,
screwed.
everybody else. So now let's jump to some
We're
questions.
gonna
guys.
super chat. Love that transition.
So go with the first one, Alexis, because this goes to the latter.
Go ahead, AB.
Oh, that's a good one. So Raspa asks, what would happen if the I-140 is approved 2 months after the visa becomes current in Table A of the Visa Bulletin for EB3 skilled workers? So I'm going to assume Table A, you're referring to Final Action Chart. So Final Action Chart was already current while the I-140 was pending. 2 months later, the I-140 is approved. Guess what? If Table A is still current, then the day of the approval, that's the day you make the determination. And as of that date, you subtract obviously the time I-140, you have a CSPA age. Now, here's a little bonus that we really didn't get into. Let's say that child's CSPA age is 20 years, 11 months, and 29 days.
Mm.
And they didn't file the AOS yet. They filed it 4 months later.
Sought
Guess
to acquire.
what? Sought to acquire. You have 1 year from the day the determination may be made to file for stage 2 or stage 3.
Hold
File
on,
for the green
hold
card.
on. So go to your example. What's the age? 20 years.
So the absolute last day, the date I-140 was approved.
1 day before 21 years old.
Exactly.
And the I-140 is approved and it's current.
And it's current. So that means that day I can make the determination.
And we made the determination that day they're CSPA protected. I have up to 1 calendar year to file an AOS in the US or
Bingo.
to
Consulate.
or to get the visa at the consulate. What happens if the consulate takes too long and the interview's past 1 year?
But sought to acquire is the filing of the
The
DS-260.
DS-260.
I know.
Oh, were
But
you
I'm
lobbing
saying-
that?
I'm like, I know what it is. I'm
I thought you were
giving
lobbing. I was like, wait.
I know what sought to
You know-
acquire means. Don't worry. So I'm giving it to you guys to explain to people. So for them to think, oh,
Yeah.
big deal, they took a year for the interview. It doesn't matter. You're
Absolutely.
still in, and the reason you're in is because you already took the steps necessary with the MVC to get it going.
So what are
Okay?
a few things that constitute sought to acquire? Of course, I-45 filing,
Yes.
DS-260 filing,
I-824 filing. Learned that one the hard way.
which is a great one.
Yeah.
By the way, I've read about this
I remember when that
hypothetically,
happened too.
but remember the I-824, it was a matter of, well, you can't file an I-824 until you have the green card.
But then USCIS
But
says
they have pushed it, and
Yeah.
I think Department of State also, as you could, I don't want to say, I don't want to use the word frivolous, but in an untimely manner, file the I-824, and
I would file.
would work.
So the moment, if
Uh-huh.
you have an age out 21-year-old kid and with the CSPA calculation they're in today, right now, file that I-824 for consular for following to join,
Mhm.
even if you don't have your green card yet. So typically what Alexis was mentioning, we will receive the green card first for the main applicant, mom, dad, that's the primary.
Mhm.
And then if the kids are outside the US, we would file I-824s to start consular processing them. I would not waste those 7-9 months of the process. AB, you're out, I think. Stephanie keeps pushing a button there. It has
I'm
your
not.
it has your face on it with a line going through it.
I'm literally not.
And she just pushes a button.
I
there
don't
and you're
know
gone.
why it
So-
keeps doing it.
Just the sought to acquire, keep in mind, USCIS itself kind of says it in a weird way on their
Mhm.
website. And they're like, yeah, you may want to file the I-824 as
Yeah.
soon as prior
They
to the
say
main
it so
applicant.
weird.
And we're like, we didn't do that in a particular case
Mm.
because that was not a thing.
procedurally,
Okay.
it's
Procedurally, you're not
incorrect.
you're not
Yeah.
supposed to do that. So we're like following the law here, but then we find out, oh, I guess you don't have to worry about it. Just file the I-824. And okay, so now that's a thing. Now we're able to do that.
I mean, the good
Anyways.
thing is you have the 1 year to seek to acquire. So,
Yes.
I think maybe within that time frame, you probably have the green card more than likely. So you might want to wait. So it's part of what we were going to consider. But yeah, I-824 will freeze it for you.
We are also answering questions not about CSPA. Yami, hello. What happens to the cases filed under 221G? This is administrative processing at the
Mhm.
embassies due to the 75 country pause. If the pause lasts another year and there's no progress, do I have to start a new process? You do not. EB2 and IW Bogota, thanks. So that EB2 continues to be approved. You will have an interview. Post-interview, obviously, they gave you the 221G sheet saying, unfortunately, due to the pause, they're unable to provide you with an immigrant visa. What will very likely happen is the pause will be lifted. You need to, and they're probably going to reach out to this group of people,
Mhm.
tell them they need new medical exams because you
Mhm.
will need a new medical exam. You will need to turn in a new sheet that you don't have a police record, like no antecedentes penales situation.
Right.
You need to provide that again, and they may interview again, but I don't believe they're going to because they already interviewed you. And they're just going to, you're going to probably send your passport in, send in those documents, give it 2 months, and they're probably going to send your immigrant visa back. Okay. If they don't reach out to us, my plan is to go ahead and contact for every single case the consulate directly and get moving on those cases. You
Yep.
could do the same.
And by the way, a lot of people are probably concerned, 1 year of not having communication
No.
becomes an issue. Here, in this sense, administrative processing, it's there. And
I still would
if-
contact within the year. Every year.
well, that's the other thing. If you have a concern, write an email. That's it.
I would still once a year hit up NVC and be like, hey,
But the case is now at the consulate, no longer with NVC, and they'll no longer respond on
but
it.
it's documented.
You know what I'm saying?
No, write to
the
the
idea-
embassy.
The idea would be, I think,
Or
right
you
to,
could write
right to
an
the
email
embassy,
to the embassy
because
as well.
I think so. Yeah.
I just want it documented,
Yeah.
Okay, let's see. Next question. Gustavo, my family and I are Venezuelans who have been waiting 19 months for approval of our EB2 and IW I-140 petition. If we want to file for AOS through the consulate, how long would that take and how viable is it to do some from within the United States? So in that case, if you want to do consular processing, remember that you do need to wait for the I-140 approval. Essentially, the NVC will not contact you in order to gather your documents until the I-140 is approved. So you can't jumpstart that step just yet. What you can do, if you wanted to, was file an AOS within the United States, assuming you have a non-immigrant status right now that permits you to file the AOS. But if not, you need to wait for the I-140 approval in order to kick off the NVC. Now, if you marked on your I-140 that you wanted consular processing, NVC will contact you automatically after about 30 days of the I-140 approval. But if you indicated on the forms that you wanted adjustment of status, after your I-140 is approved, you need to file Form I-824 to notify the consulate.
Really important, just for Gustavo, your own information. Like there's no AOS at the consulate. AOS is a term only used here
Great point,
in the
yeah.
U.S. So you would consular process
Mhm.
the case. Also keep in mind, you're still subject to the pause for Venezuelans. So
Correct.
you're not going to receive a decision, unfortunately, on that case until it's clear that the pause has been lifted. I think employment-based cases, guys, are the ones that are going to take a little bit longer. Even when the pause is lifted, they're going to prioritize, I think, family petitions.
I agree.
Probably.
I agree.
USC petitions, I think that'll probably be prioritized because they're easy to deal with and you could just already clear them out. And they were actually processing those cases really quickly.
They were.
You know what I'm saying? And employment-based, I think they're fine taking a little bit of extra time.
That kind of gets into this person's situation here, and I just looked up the time frame. But let's see. Reza asks, EB2 and IW approved, entered the U.S. with a B2 4 months ago. Okay, so assuming they gave you full I-94 for 180 days, it's about to expire in 2 months. How long would it take to get an answer for AOS once filed, and what are the potential outcomes and solutions? Well, assuming if you're not from any of the banned countries, you can obviously get a decision. If you are from a banned country, you currently may be able to get a decision. I just looked up the official time for an I-45 for a pending I-1, due to an I-140. 35.5 months is the 80% of cases.
But fíjate, that's not what I'm seeing in real life.
I agree.
Like I'm seeing the green cards issued within 6 months.
You looked at SCOPS, but
Yeah.
you if you go into the average
NBC.
Well, no, not NBC. If you go to the
NBC.
local
and
offices.
NBC,
MBC
National Bank
and
of
local offices, it's 48 to 55 months.
Which is
Exactly.
again not what I'm actually
Never happened to me.
seeing.
I got to tell you, it's never happened to me.
All
Even the
field
lengthy,
offices.
maybe 2.5 years.
Well, look,
maybe
they just
lengthy.
updated all field offices. 9 months.
No, I don't believe that.
Mine, yeah.
I don't believe that.
EB1 and EB2.
At the field office.
One applicant, an AOS, both are current in both tables. Yeah.
At the local
about 12
office.
months, maybe.
Maybe.
But going to this person's question, you're expecting a response in 1 to 3 years. That's the average time.
Well, he's talking about we're talking about potential outcomes.
Potential
You know,
outcomes.
Stephanie
EB2
says
NW
could be
approved.
9 months, could be 3 years. You know,
And assuming you're not from a banned
how
country.
about this? Is it advisable coming in as a B2 and
Start.
filing an adjustment of status application?
What's the memo?
Yeah, I mean,
Guess what?
Look, you're gonna have to work a little bit for that. Do we actually want to do that? You know what I'm saying? Like you're right now, you have it. This is what I'm guessing. You're subject to the 75 countries at your home consulate, and you don't want to wait the time maybe outside of the U.S. for this. So you're contemplating entering the U.S. I would have been on board with you a month ago.
Mhm.
Right now, I'm hesitant to do that. The cases that I'm still green lighting it,
Other non-immigrant statuses.
marriage to USC. Marriage to USC.
Oh, if it's
I'm
entry
still
as a B2,
yeah,
agree.
I'm still
Yeah.
green lighting that. I'm
Also,
like
F2A.
and that one's
Maybe.
still probably okay. But I'm talking like employment cases. Ah, man, I don't know. If you have an F1, yeah, I would go for it. If you have a work visa, clearly, I would go for it. But anyways, just putting that out there because I think the most important question is, should you even do that?
Mhm.
Like,
Well, the current government's take is you should do this consular.
Yeah.
That's their approach.
But
So
then
you're
again, they
coming
came
in-
out and said no.
Well, unofficially.
True.
So we don't know. It's so new that maybe ask me again in a month or two. But guess what, Reza? You have 2 months. You want to know what to do? Probably get on an F1.
they like to go by Ofnami.
Oh, sorry.
I don't know.
I would say, hey, maybe they qualify for an 01.
Stephanie,
you have
this
an
is
EB2
for
and
you.
IW. I don't know.
Steph, that's for you.
Let's go, Yanireth. I received a NOID on my F1 change of status application. Can I request to withdraw that application without it conflicting with my I-45 and I-4-140 EB2? Okay, great question. Also worth mentioning here, we are receiving dozens of NOIDs that were changing status from TPS to F1. Every single one of them is citing the presidential proclamation that was basically indicating that we have security national concerns for Venezuelans. And every single one of them says the exact same language. While we know this doesn't apply to you because you entered the United States prior to the date that was supposed to be indicated by us, we still want to see if you're a person of good moral character. When I say dozens, we have received dozens within the past 2 weeks. So this is very, very common. If you are in a situation where you have received annoyed because you were changing from TPS to F1, contact us because we're answering these by the dozen and you need to be able to respond. Yanira, that goes to my response. I am not a fan of withdrawing that application, though you probably will be protected by 245K, which is why you're indicating this. I would rather respond and get a denial at worst, but I would rather respond.
What do you believe is going to happen when all these cases are denied?
They're not going to be denied.
Don't
say that out loud.
When these cases are denied, you need to be careful that the notices to appear are going to start rolling out, regardless of the fact that the I-45 is pending.
Yes, but we have many, many arguments that we can use in our favor.
I know.
And I truly, truly think there cannot be a world where they just deny all of these petitions based on a presidential proclamation that is so explicit on the date.
The worst thing is
so explicit on the date. I think they're just buying themselves time.
I think the worst thing that's going to happen is that entire group of people is subject to a pause, and we're not going to have a response on those cases until the pause is lifted.
Well, in theory, the immigrant benefits pauses has been raised.
No, what are you talking about? For non-immigrant, for NIVs?
Oh, sorry.
That person, I'm telling you, that person, the Noid, what she's talking about, that has to do with the 19 countries or the 39 countries. Excuse me, 39 countries. Okay. So it has to do with that. So like it has to do with that. The reality is that you're subject to that. You're not going to have a decision. So what they did is they internally said, RFE every single one of these. When Stephanie meant we're getting dozens, we're getting dozens.
Yeah,
okay.
Everybody's
getting. I'm answering.
And it's the same one over and over, by the way.
It's the same. It's copy and paste. It's
the same one over and over. They just sent it in order to say they took action on it. Because why? Let's think conceptually about this. Because they have a lawsuit that basically says, hey, listen, you can't be inactive when you're collecting money. They said, okay, don't worry, we won't be inactive. We'll collect your money and we'll be active.
That's a great point.
They sent Noids and they just copied and pasted every single one, but they're not going to give a final decision. But now that they can justify their fees because they took action. Yeah, basically. Exactly. But for me, I would not withdraw. I would respond.
No. You cannot withdraw that case.
I would not.
I want a denial. Let it be denied because you could appeal. You could appeal. Okay, so you could appeal. So what Stephanie says, you could file a federal lawsuit. You could do a lot of things there. You must. And this is, I just want to be clear here about something. If they're denying the F1, what's going to happen to the adjustment of status? It's magically going to be approved, the adjustment of status, even 245K.
I just don't see a world where that happens.
There's
so many people.
The reason they're going to deny these F1s is because they're going to say you're subject, to you're subject to the proclamation. It's a security concern. Sure. It's this or that. What is that? That's the same thing for an adjustment of status.
A great point.
You know what I'm saying?
So if I'm subject for security for A, how am I not subject to security for B?
So I'm just saying, I think we have to go guns blazing to win these cases. And no, I'm not being negative about it. I'm being realistic. I feel you made such a valid point there, which is this is the lawsuit situation. This is, highlighting the fact that we're taking action on cases. Hopefully that's all it is.
I hope so.
But I think it's part of a pattern of kind of this malicious interpretation of immigration laws to screw people over. Okay. And that's it. It's very shocking for me to speak that way, to be honest with you, because I never thought about it that way. And I thought about it it's like we're a sovereign. We have the decision how to establish immigration laws in the US. Absolutely. For which people we allow into the country, for which people we decide not to. The United States is sovereign. We have a right to do that. Yes, I still believe that. However, how they're going about things with certain classes and groups of people is fundamentally unfair and, in my opinion, incredibly un-American. Okay.
And by the way, un-American in the sense that they're reinterpreting what the laws and regulations are that are set by Congress. If we want a different outcome, there's a process for it.
Hey, by the way, we'll handle that Noid for you if you want Stephanie to handle the Noid for you. Okay.
Chop it up to the list. Here, I'll take a crack at this. Ana Catalina, hola. Well, I'll put it in English.
You got to go Spanglish, man.
Hi, my son is going to turn 21 in September. We have an EB3 other worker, I-140 approved. Without premium processing, 7-day response. Our priority date, June 2024. You got to give me an exact date. What do you recommend? We're currently on an F1, F2, so student and derivative visa. So other worker, the priority date is February 1st, 2022. More than likely, your son will, from here to September, the priority date will not be under the final action chart, be in your favor. Recommendation, get in on an F1 immediately. Start doing the F1. He's going to turn in September. Start now. I'll respond in Spanish, since you did ask in Spanish.
Did you see that though? That I-140 was approved in 7 days without
No
premium.
I saw that.
Without
too.
premium
That's
problem.
crazy.
Without premium. You know, what am I
We
thinking
are
there?
fasting responses.
What do you think there? What do you think the reason is for that?
Maybe they knew about the CSPA child.
Yeah, like why why?
Maybe.
Okay, so can we
Maybe
walk
the
it
company's
through?
really good.
Let's walk it through for Ana Catalina. Okay.
Right.
So we're doing pending time, and your calculation is 7 days.
Absolutely.
Your age at time of visa availability, let's say it's within 2 years. So he'll probably be 23 at the time when this finally becomes current and on the final action chart.
That's
So you're
conservative.
only gonna subtract 7 days from his 23
From
years,
that day.
which is probably why he's not gonna be protected by CSPA.
Exactly. So we have to assume that what you're subtracting, the day that they make the determination based on the final action chart, is 7 days. It's so little,
Right.
it's so nominal that
Listen,
percentage
he needs to
likelihood's
get
not
on
there.
his own individual F1. Again, we're not
F1.
saying not to do an AOS in the future for him. I'm just saying you keep him on F1 status. By
Mhm.
the way, in September, you need to do this by the time he turns
You have to do
21
this now.
September.
You have to do
Like,
this
we
now
have to do
already.
it now. Yeah.
Next month.
he
Yeah.
needs to start school now
Yeah.
in August or September.
You know, Alex, I saw here a follow-up to Raspa, and just to make sure, read that one. That was you.
Raspa. Okay, Raspa. So you have here priority date February 28th, 2025. 21 now August 2026. EB3 skilled worker. So I know the priority date's 2024 there. Right?
Yes.
Yep.
Yes.
So will a miracle happen and my daughter be protected? So let me just run through this again. Priority date is February 28th, 2025.
But hold on. Filing date
When was the I-1?
is July 2025. They're filing it. Excuse me, July 2026. He's filing next month.
Sure. You could file the AOS whenever you'd like.
So priority date doesn't matter, Raspa.
Well, I'm just looking at it to see the final action date chart to see how far away they might get to determine it. So let's say each month the visa bulletin advances. If we're in June 2024 and the priority date is February 2025, hypothetically,
Filing date. Filing date. This is a perm. They're filing the I-140 next month.
oh, I'm sorry, they haven't filed the I-140.
Exactly.
Oh,
He
it's
said this
somewhere
in
else.
somewhere else. That's
Sorry,
what I'm trying to
okay.
explain to you. Yeah.
So
yeah.
you have to file the I-140 first and see how long that's going to take. But if same thing happens like Ana Catalina, they have a decision in 7 days. And so it's not beneficial. August 20, I don't see.
He said he's filing the I-140 next month.
It's
Probably because
hard.
he's waiting.
I think she's so close in age, regardless, you have to file the F1, change of status. You have to protect your daughter, put her on an F1. And I mean, you acknowledge it. Will a miracle happen? It's possible. There might be a big jump, but have we seen a big jump on EB3? It's been in that 2024 all
For a
year.
minute.
What happens, Alexis, if we don't file the I-140?
I would file the I-140.
What if I don't file? Okay.
If you wait till she's 21, then you're always the amount of time will always be above the age of
21.
Yeah.
So
But definitely don't file that I-140 with premium.
no premium.
Right.
No, no premium.
I
No
think
premium.
the strategy here is, and you're taking the gamble, but this is what's gonna. It's a game of probabilities, right? So you really have to love math and betting to really get into this. I-140, you wanted to be pending as much as possible. The longer it's pending, the more you can subtract. Also, the longer it's pending, the likelihood you get to a date where a date and time where the final action chart will finally be current. And that's what you want to look at. And so I mean, hypothetically, I have 3 EB3s pending that we filed, one in January, one in March, and one in April.
Do you know that I-140s? I just looked it up. I don't know, an hour ago. 3 months.
Officially?
For EB3?
Shut up. Officially?
Because my client's like, should I pay the premium? I'm like, let me see how long it's taking. I say, it's 3 months. Are you crazy? Where are you going to pay the premium? It's 3 months. Okay, nationally.
Wow,
Yeah.
wow, wow.
Okay. So I think by my
EB3.
experience, it's closer to 6 to 7 months. But even if it is, we're still, his visa number was the same. It was Jan 25, and we're working on June 24. Okay. So I'm
It's
like,
hard.
I said,
Too hard.
do not do the premium processing
Because you're probably going to get.
I said, why are you gonna give $3,000 away? Like,
It's not
Yeah.
like EB2 and AW that you're talking about 2 years, 2.5 years.
no, that makes a lot of sense.
Right?
Yeah.
EB1, 6 months. Man, Raspa, I'm so sorry. Get the F1, I-140. Do not hit premium on there. If by chance final action date chart becomes available at some point, even while the I-140 is pending, at that time, file the AOS. But at least protect her with the F1 now, since there's no immigrant intent issue there at all. I-140, I guess you're soon to follow. Shouldn't affect her either way, but.
Lightning round?
Rapid fire. Ana Maria from Instagram, I think. I thought turning 21 automatically my child was out. Not necessarily, Ana Maria. This gives me hope, but also makes me realize we need to act carefully. Thank you very much. Absolutely, and very good advice. Salvatore. Gil has always been very, very careful about these details, not just about filing a case, but also protecting the whole immigration strategy. He is a family man. I am a walking family man. Thank you very much. Hola, tropis. I'm just going to hit 3 back to back. Then you guys go. Hola, tropi. Well, tengo I-140 aprobada. Oh, look at me. Look what you just made me do. Now I got to go back and say it in English. Hi, tropical attorneys. I have an I-140 approved since October of 2025, but I have not received the physical approval. What happens with his cases, EB3, other worker? You need to request, the employer needs to go ahead and request the I-140 approval to be sent. You might be required to file a I-824. That's our magic form of the day. I-824, did you guys ever watch, I'm really dating myself, but did you ever watch Pee-wee's Playhouse?
Oh, yes.
It was on TV, on CBS. And this was a morning show on Saturdays. Kids will watch, Pee-wee Herman. Okay. So, his whole backstory. So, it was Pee-wee. And then he would say, it would be like, the magic word of the day is, I-824.
Sure.
And then every time I-824 was said, the place goes wild.
Blows up, yeah.
Anyways.
Do you guys remember when Gil said rapid fire?
Sorry. I know. Sorry.
Here's a quick one because I think it's really important. You got it?
Go.
Just in case.
No,
Go.
Got it?
Go. In summary, Manuel asks, I have never heard about CSPA before. Is this something that applies automatically, or do we need to request it? You do not need to request it. It is automatic.
That's incorrect. It's a box on the I-45.
CSPA?
It's a box on the new I-45.
Okay, you got me there.
Okay,
It's on
it
the
is
new
it
one.
is 100% on there, yeah.
But
You
either way,
must request it.
I guess do request it, but in the event that the child wasn't, it wasn't even a matter to request at the time, it should be automatic in the sense that officer needs to make that determination. And either way, you too, be mindful of it, because if there is a request for evidence in the future or you go to an interview, be prepared to present why the child qualifies under CSPA. But it's a box to mark.
Department of State, it's automatically handled by the officer.
Sure.
Okay. And there's no box to check. There's nothing of that nature. When you get your fee bills from the Department of State, from the NVC, if you see that your child is excluded, you ask them, I want them to be included. They might respond, hey, listen, we see that your child is over 21. I want you to respond exactly this. I understand. I would want this determination made by the consular officer because you have that right. So they will add the fee bill.
Say that one more time. Say that one more time.
The Department of State is going to send the fee bills. Let's say they don't say the fee bill, send the fee bill for your adult child. You're going to go ahead and respond to them and say, please give me the fee bill for the adult child. If they tell you, but he is under 21, you say, I want you to send it to me because I want that determination to be made by a consular officer. You have that right, and the consular officer is the only one who has the right to be able to make the CSPA determination. So I want you to pay the fee bill for the adult child and let that calculation be done by the consular officer. I cannot tell you the amount of times that NVC did the CSPA calculation wrong, and my consular official who has more experience in this does it correctly. For adjustment of status purposes, on the new AOS form, there is a box where you do have to check, please do a CSPA calculation.
Okay, so I was half
That
right.
was spectacular advice. Wasn't that spectacular? Where are you going to hear that advice? Let's be honest.
You got to tune in.
Where are you going to hear about that NVC? That is such a great tip and advice for people, because I imagine there might be people that are like, oh, that's it. They said no. They said no. you know, and it's wow, that's phenomenal advice. Very
Thanks,
good.
Gil.
Very good.
The
Very good, very
consular
good.
officer has the ultimate right to make the CSPA calculation.
And by the way, sometimes you win it
Yeah.
because you're right. That
Oh
person
no,
doesn't
of
know.
course, of course.
Because they're going to have more experience than the NVC.
Oof. I'm going. Are we
Yep.
Oh damn, no, bro. Antonio's like, yo, this is exactly why I
Mhm.
wouldn't trust a form preparer with something like CSPA. Hell no. It's like hell no. With CSPA, listen, you got three pretty good immigration attorneys right here, and we're telling you it ain't that easy. Okay, one bad calculation can put your child's future at risk. Absolutely,
True.
absolutely, yeah. I think we're done. We done?
Oh, you guys are the best.
Tune
you,
in on
Nicolas.
Thursday. Tune
Oh
in
yeah,
on
let's do the
Tuesday.
Spanish show. We'll do the Spanish
We
show.
should actually
Spanish
do this in
CSPA?
Spanish.
That's
The
crazy.
CSPA in Spanish is
It's
gonna
be
drive us
awful.
crazy.
It's gonna be so brutal.
That's gonna.
But we should, because this is really good information.
Yeah, we should. All right. Well, the thing is, the Thursday has a lot of questions.
The Thursday has so many
A lot of
We
questions.
got to do a
So
segment.
maybe we'll do a
record
15-minute
segment.
segment. You know, we should also, by the way, we should also just shoot a video on it.
I think
Oh,
so.
yeah.
That's not live.
That's a great idea.
We should shoot a video on it. That's not live. Kind of basically what we did now, but
Yeah.
just more professional.
Yeah.
You know,
You,
I think
we
it
were
looks
professional today.
more not lazy like I am today.
No, you're not. You did great.
Thank you. Well, thank you, everybody. I will see you. We will see you Thursday at noon. The Spanish show next Monday. It will only be a two-headed monster.
Next Tuesday.
Next Tuesday, it'll only be a two-headed monster because I'm not going to be here.
Surprise.
But maybe Andrea will fill the seat.
That's true.
Ooh,
Maybe we'll get
That's true.
Andrea in here.
I'm gonna talk to that.
Bye.